Hi everyone. So my project is on the Te Awa Tupua Act of 2017. What I will be covering in this presentation is an introduction, my research question and methodology, argument, theory, analysis, and tentative conclusions. So the New Zealand Parliament passed the Te Awa Tupua Act of 2017, and the Act grants the Wanganui River all the rights, duties, and liabilities of a legal entity, and it also recognizes the Wanganui as an indivisible whole and living whole that supports the local Maori tribes. The Act also appoints two guardians to act on the river's behalf. One is an appointed Maori representative and one is an appointed government representative. What the Act does not do, however, is grant the Maori full property rights or legal ownership of the Wanganui. The Te Awa Tupua settlement brings to a close New Zealand's longest historical water dispute, which began in 1840. Many of New Zealand's rivers and lakes hold spiritual and cultural significance for the Maori. This is because the Maori have a holistic view of nature and see the welfare of natural resources as inextricable from human welfare. So the Wanganui is the first river in the entire world to receive full legal status. The Maori have constantly fought to secure their cultural, spiritual, and social rights over the Wanganui River, and they depend on the river for food, water, tourism, and valuable ecosystem services. Over the past several decades, however, the Wanganui's water quality has significantly decreased due to activities such as farming, forestry, and hydropower development. Granting legal personality to natural resources is not a new concept in New Zealand law. It was done in 2014 for Mount Taranaki and the Te Urewara National Park. However, the Te Awa Tupua Act provides an unprecedented legal framework for water resource management. And what it does is it shifts the perception of nature from an anthropocentric view to an ecosystem-based view by fostering a mutual respect between humans and the environment. It is also an important step forward for Indigenous rights because it recognizes and acknowledges the Maori's cultural and spiritual beliefs. So, the question that I'm looking at here is, to what extent has the Te Awa Tupua Act of 2017 impacted the ecological health of the Wanganui River system in local Maori tribes? The methodology I'm using here is a case study, single subject, and I'm using the theoretical concepts of legal effectiveness, enforceability, and property rights theory to analyze the Te Awa Tupua Act in order to assess its impacts on the ecological health of the Wanganui River system and local tribes since 2017. And I use news articles and academic literature to collect my data. So I argue that the Te Awa Tupua Act is embedded with the institutional mechanisms to be effective, enforceable, well-defined, and defendable, based on the theoretical concepts of O'Donnell and Talbot-Jones and Talbot-Jones and Bennett. However, despite the legal significance of the Te Awa Tupua Act for ecosystem-based water resource management and Indigenous rights, the Te Awa Tupua Act has yet to provide positive, tangible ecological benefits for the Wanganui River, its surrounding natural resources, and local Maori tribes. So O'Donnell and Talbot-Jones argue that despite the innovativeness of the Te Awa Tupua Act, it presents complex challenges for environmental law and management. Namely, in order for the Te Awa Tupua Act to be successful, the Wanganui's rights must be effective and enforceable. To be effective, the river's resource users must observe and uphold the river's rights and responsibilities. This depends on the river's guardians and pre-authorized resource users. To be enforceable, there are three criteria. First, an individual or organization must be appointed to act on the river's behalf to uphold the rights of and speak for nature. Second, capacity in the forms of time, money, and expertise may need to be available so that the rights of the river can be upheld in court. Finally, river representatives and funding sources are likely to need some form of independence from state and national governments, as well as sufficient real-world power to take action. In other words, the Wanganui's guardians must be decoupled in some capacity from state and national governments in order to judicially enforce the river's rights. So, rooted in property rights theory, Talbot, Jones, and Bennett argue that the Te Awa Tupua Act creates a new property rights system which they term resource self-determination. They argue that in order for this new system to be successful and for the Te Awa Tupua Act to achieve its policy goals and objectives, the Wanganui's rights and corresponding duties must be well defined and defendable. They assess how explicitly the decision-making authority is defined within the Act. And what they find is that the river's guardians have the ultimate decision-making authority regarding water management, access, and withdrawal. and pre-authorized users will retain their rights to access to and withdraw from the river's resources. They conclude that overall, this new system of resource self-determination has the potential to be successful because the river has appointed legal guardians to make vital decisions regarding the allocation of first-order rights to access and withdrawal. So, in order to apply these theoretical concepts to my research question, we first have to look at the current state of the Wanganui River. Despite the river's new legal status, it is still facing complex ecological challenges. A 600-page report released in August of 2018 by the Waitangi Tribunal concluded that the New Zealand government allowed a serious degradation of water to occur in many ancestral water bodies under the Resource Management Act. And one Maori leader, Gerard Albert, he says that the law will take years to have an impact. One of the biggest obstructions to reaping the ecological benefits outlined in the Te Awa Tupua Act is Genesis Energy, a New Zealand hydropower company that diverts water from the Wanganui and 5 of its tributaries. Since the 1970s, the system has had significant negative ecological impacts on the health of the Wanganui, such as leaving certain riverbeds dry, reducing water clarity and visibility, and raising overall water temperature. And it's important to note that in 2004, Genesis Energy was granted the rights to access and withdraw the Wanganui's resources until 2039. As previously mentioned, existing rights to access for pre-authorized users will remain intact under the Te Awa Tupua Act. So, in order to figure out what this all means, a few questions must be considered. Is it effective? Are the Wanganui's rights being observed by resource users? The answer is unclear, because while the Maori tribes definitely observe the Wanganui's legal rights, there remains conflict with pre-authorized users over the river's resources, such as Genesis Energy. Is it institutionally enforceable, according to O'Donnell and Talbot Jones? Is someone acting on the river's behalf? Yes, because the river has 2 appointed guardians to help judicially enforce its rights. And was it allocated funding? Yes. The New Zealand government provided funding to help implement the act and provide ongoing assistance for upholding the river's rights. Are the guardians and funding independent from the state and national governments? While it's unclear whether the guardians and funding are completely uncoupled from state and national governments, the Te Awa Tupua Act diverts greater control of the Wanganui's resources and management back to local Maori tribes. 3. Is it well-defined and defendable according to Talbot Jones' Bedem? Tentatively, yes, because the river's guardians possess the ultimate decision-making authority, and the Act clearly states that pre-authorized users will retain previous rights to access and withdrawal. So, what is the bottom line? Institutionally, the Te Awa Tupua Act has the legal mechanisms to be successful according to the theoretical concepts discussed by O'Donnell and Talbot Jones and Bennett. Physically, however, it has not yet produced positive ecological impacts on the health of the Wanganui, its surrounding natural resources, and local tribes. This is largely due, in part, due to the hydropower production of Genesis Energy, which diverts water from the Wanganui and has had negative ecological impacts on the river. So thank you very much, and I will take feedback, questions, comments, and concerns.